Our next case is South Dearborn Environmental Improvement Association versus Department of Environmental Quality. Okay, thank you. My understanding is we have 20 minutes per side in this case. Please proceed.
May it please the Court, my name is Neil Gordon. I represent the Michigan Department of Environmental Quality. With me today at council table is Aaron Lindstrom, the Michigan Solicitor General, and Adam Hall, who represents AK Steel Corporation. Of the 20 minutes that Mr. Hall and I have been allowed for oral argument, I will argue for 12 minutes, and I would like to reserve 2 minutes of my time for rebuttal, and Mr. Hall will argue for 8 minutes.
Okay, but please do keep track of your own time.
Thank you, Your Honor. The Court of Appeals made a clear legal error in this case when it held that Michigan Court Rule 7.119 applies to this case. That court rule governs an appeal to the circuit court from an agency decision when there was a contested case, that is, an evidentiary hearing before an administrative law judge. But the Court of Appeals held that 7.119 governs this appeal even though there was no contested case, and instead there was only a public hearing on a draft version of the permit that the Department of Environmental Quality proposed to issue. The Court of Appeals error, if it's not corrected, will have significant consequences for both the state's jurisprudence and for state agencies. It will result in the circuit courts applying the wrong court rule to appeals from agency decisions when there was no contested case, and it will result in parties claiming a right to a contested case where none has been provided for by law. Now, that court rule, 7.119, states that it governs an appeal to the circuit court from an agency decision where the APA, the Administrative Procedures Act, applies. So to determine which appeals the APA applies to, it's necessary to look to the Administrative Procedure Act itself and its judicial review provisions. So the APA provides for appeals for two kinds of agency decisions. First and foremost, it provides for an appeal from an agency decision in a contested case, and it also provides for an appeal from an agency's declaratory ruling. Well, this appeal is neither of those. There was no contested case, and it's not an appeal from a declaratory ruling either. The court rule that governs this appeal is 7.123. That is the catch-all court rule for an appeal to the circuit court from, and I quote, an agency decision that is not governed by another court rule. The Court of Appeals erred when it based its holding on a particular licensing provision of the Administrative Procedures Act, Section 91 sub 1, and it misinterpreted that provision. So Section 91 sub 1 states, when licensing is required to be preceded by notice and an opportunity for hearing, the provisions of this act governing a contested case apply. The Court of Appeals misinterpreted the word hearing to mean a public hearing rather than an evidentiary hearing. And the Court of Appeals ignored the fact that the contested case provisions of the APA clearly apply to evidentiary hearings, not public hearings. Those contested case provisions in the APA include procedures for witnesses to be examined, for evidence to be admitted, and for an administrative law judge to preside and make rulings. And in addition, that court rule, 7.119 itself, demonstrates that it governs appeals from agency decisions in a contested case, not appeals after a public hearing when no contested case occurred. For example, the rule provides for motions to allow for the taking of additional evidence before the agency, for rehearings, and for the circuit court to reverse the agency's decision if it's not supported by competent material and substantial evidence on the whole record. Those are all procedures that are applicable to a contested case, not a public hearing. So the court rule that governs this appeal is 7.123, under which appellants had 21 days to file their claim of appeal. They filed after 21 days, 59 days after DEQ issued the permit here. This court should therefore dismiss this case. Now, regarding their arguments as to they should all be rejected. First, they claim that the Court of Appeals' reliance on the public hearing that DEQ conducted here is simply dicta for its holding. That is not correct. That public hearing was a fact before the court and is one that the Court of Appeals and the Circuit Court specifically relied on as the factual basis for its holding. Second, they claim that 7.119 applies to all decisions of APA agencies, and that's clearly not wrong. That's clearly wrong as well.
Counsel, why does it matter?
The court rule that matters which court rule applies because each of those two court rules prescribe different time periods for filing the claim of appeal to the Circuit Court.
But if you hold the APA applies, why does it matter?
If you hold, the APA does not, our position, Your Honor, is that the APA does not apply to this appeal from this agency decision because.
But if you were to hold the APA does apply, then does it matter?
If the APA applies to this decision, I think it still doesn't apply. It doesn't apply within the meaning of 7.119. I mean, on some level, even 7.123 concerns appeals from agency decisions that are APA-defined agencies. But within 7.119, the question, that first section of 7.119 is asking, is this an appeal to the Circuit Court where the APA provides for an appeal to the Circuit Court? And the APA does not only provides for appeals to Circuit Court in two limited circumstances, after a contested case and after a declaratory ruling. That's what that court rule applies to and provides a particular time period for filing claims of appeal. The court rule that applies here that governs this appeal, where there was no contested case and there's no declaratory ruling either, is 7.123. And it matters because it prescribes a different time period for filing your claim of appeal. You have to file your claim of appeal within 21 days. You get a right to an appeal. You have an opportunity for judicial review. It's just that the court rules specify that the time period for filing that claim of appeal is 21 days. So that's why it's critical that it matters in this case, because it prescribes a time period that they did not meet. And that was the basis for the motion below, the motion to dismiss for lack of subject jurisdiction, because they were too late in filing their claim of appeal.
Counsel, can I ask you a question that just jumps out at me, but apparently didn't jump out at anybody else, since I didn't see any reference to this argument in either side's briefs? And that is, what is the relevance, if anything, of this Court's decision in the Cleveland Cliffs case or the United States Supreme Court's decision in the Lujan case, in which the language "any person" being allowed to sue in an environmental case seemed to transgress the concept that standing was of constitutional dimension and couldn't be imposed upon any person by a legislative body? Why is there no reference at all to Cleveland Cliffs? Is it that Cleveland Cliffs is no longer the law in this state, or what is the reason that that's not been referenced by either side in this case? Any person.
Well,
we had a similar language in Cleveland Cliffs, and we had similar language in the Lujan case, in which it was argued successfully in both cases that any person would encompass a large range of individuals who didn't have standing under traditional concepts of standing. And related to what I've just asked you, is there an argument that the plaintiffs in this case do have standing under traditional precepts of standing?
Yeah, Your Honor, and I think you're referring to this provision in the air pollution statute, Part 55 of the Natural Resources Environmental Protection Act, Section 5506 sub 14, where it refers to how any person can file a challenge to a particular type of permit. And similarly, that phrase, any person, is also used in Section 5505 sub 8. It also uses that phrase, any person. So, Your Honor,
Is plaintiff any person, or is plaintiff someone who, in fact, has suffered at least arguably a particularized injury by what occurred on the part of defendants in this case?
Well, Your Honor, in interpreting the phrase "any person" as it's presented in those two statutory sections, I think we can only go to the language of the statute itself, and the statute itself does not specify whether they have to be have suffered an injury. It doesn't, and so it is broad in that sense. That issue was, you're right, it was not addressed below. And similarly, when it says any person in Section 5506, again, the language of the statute does not say any person who has suffered an injury. Honestly, Your Honor, the question of standing, we didn't get to that issue yet in the proceedings below.
Isn't it traditionally understood as a threshold question in these kinds of cases?
It would, although frankly, and it may well, if this case is remanded, it may well come up. Before we even got to that threshold issue, there was an even earlier threshold issue was, did they file their claim of appeal?
I thought you might respond by saying it wasn't raised in this case because arguably Cleveland Cliffs is no longer the law of the state concerning standing and has been subsequently preempted by this court's later decision in the Lansing case. I guess I'm quite confused as to what you think about it right now, but specifically, did plaintiffs here suffer any kind of particularized injury?
They are alleging that they did suffer a particularized injury. That is correct, Your Honor.
And what is your view on that?
We actually are not contesting whether or not they suffered any injury. These individuals who are members of the South Dearborn Environmental Improvement Association are people who live near the steel mill at issue and are affected by the emissions and the operation of that facility. So we do not dispute their claim as to whether they have standing in this case.
Okay, thank you.
Yes, Your Honor. So moving to the second issue here, our view is that on the first issue, the Court of Appeals made a clear error as to which court rule applies, and it applied the wrong court rule, and on that basis, the case should be dismissed. As to the second issue that the court directed supplemental briefing on, the Court of Appeals correctly determined that Part 55 of the Natural Resources and Environmental Protection Act does not provide for an appeal for this permit by these appellants, and that the air pollution statute does not prescribe the time period for that appeal. We think the Court of Appeals made that decision correctly. The permit at issue here is what's called a permit to install. It's an air pollution permit that authorizes emissions for an existing source, that is the steel mill in Dearborn, owned and operated by AK Steel. And it's important to note who filed this appeal to the circuit court. It was not filed by AK Steel. They were content with the permit. It's filed by third parties like the South Dearborn Environmental Improvement Association. When you parse the two provisions in Part 55, the Court of Appeals correctly determined that it does not provide for a right to judicial review of this kind of an appeal permit for an existing source when it's filed by third parties. There are two statutory provisions at issue here. The first is Section 5505 sub 8. It addresses judicial review of certain permits for new sources of air pollution. That's not relevant here because this is
it directs you right to 5506.14.
It does.
And the meat of this question is whether in the last sentence a petition for judicial review is the exclusive means of obtaining judicial review of a permit means any permit or an operating permit that's mentioned in the sentence before, or even a general permit or a permit authorized under the rules promulgated under Section 5506, which is mentioned in the beginning. And your position is when it says a permit, it means operating permit.
It refers back
as the Court of Appeals found.
Correct. And I think that interpretation is consistent and is based on the context and the structure of 5506 sub 14 generally. That statutory provision is organized really into two parts.
But it really tells you in 5505.8 that You have to go to 5506.14 to find out how to appeal for an existing source. And that's what you have here, is an existing source, right?
That's right. Although that last sentence of 5505 sub 8 does not say appeals of all permit actions for existing sources are subject to 5506 sub 14.
It doesn't say for some existing sources either, does it?
No. So what the reader needs to do is review 5506 sub 14 to determine which types of permit actions for existing sources are provided an appeal. And when you go read 5506 sub 14, you see that it does not provide for an appeal by third parties of a permit to install for an existing source. So, I mean, the argument that, yeah, that cross-reference somehow answers the case, I think which is an argument that they make,
right,
is just off base.
I think your co-counsel is jumping to get at the podium.
I see that, and I want to give Mr. Hall an opportunity to argue, so I will step down and reserve the rest of my time for rebuttal. Thank you.
Apologize if I appear impatient, Your Honor. I think I have about 5 minutes left of our time. My name is Adam Hall. I'm representing AK Steel Corporation. To go to the argument under Part 55 of the Natural Resources Equal Protection Act first, as the cross-reference section. Had that cross-reference used the word permits to install for existing sources in that last sentence of 55 subsection 8, then I think this court would have to ask itself a difficult question. Where is that in 5506 paragraph 14? But it doesn't say that. It just makes a generic reference to existing sources. And when you go to 5506.14...
But given the beginning of 5505.8, at the beginning where it makes reference to a permit to install, a general permit or a permit to operate authorized in rules promulgated under Section 6, why isn't it reasonable to say when they're referring to that, in that last sentence, appeals of permits is referencing the permits that are described above, including permits to install for existing sources?
There are a lot of different permits referenced in there's 3 different types there up for the new sources.
Right.
And then there's a generic reference to existing sources, not particularly to permits to install. And then it just tells you, go look at 5506.14. When you go look at 5506.14, there are 2 different types of appeal rights created. There's one that fits into that cross-reference, and that is for permits to operate under 5505 subsection 6. And it creates a different set of permit rights for judicial review, particularly for owners and operators only, not for any member of the public. And it's a contested case procedure with the judicial review under the Administrative Procedures Act. Then there's a separate one that's for operating permits only down below. And the natural reading of that, those 2 sentences together, is for operating permits. So that is how the cross-reference fits into that section. The legislature knew full well how to create a right for different types of permits. It did so explicitly and clearly in both these subsections. It just did not do so for permits to install for existing sources. That, I would submit, is where the analysis should end. I understand why it's difficult to do that, because you're left with the question, well, why did the legislature carve that out? They don't tell us. But they clearly did. When they created that right for judicial review in 90 days for those different types of permits under Section 5505, they did it only
But counsel,
as to new sources.
But isn't this going to make it hard on the public? Because when you do an analysis of this, aren't most sources going to be existing sources? So to leave that out is quite significant and could have a real impending impact on the public at large, wouldn't it?
Well, permits to install, Your Honor, or also sometimes referred to as permits to construct, frequently do apply to new sources as opposed to operating permits. They can also apply to existing sources.
But we're talking about existing sources are going to be the most prevalent type of permit that's going to be issued. You're not necessarily always building new factories or new things. You're going to be working and repairing on existing things. So the question here is that for something this significant, shouldn't it have been spelled out? And now that we have some ambiguity, shouldn't this be of concern because of its impending impact on the communities that live around these facilities?
The question is, should it have been spelled out is a good one, but it was not spelled out by the legislature. And as this Court's prior jurisprudence has indicated, if the legislature omits something, it is not this Court's function to supply what was omitted. And that's what you have here. There is no provision in either one of these sections that deals with permits to install for existing sources. That was left out by the legislature consciously. If they had intended to do what the environmental groups have argued here, which is create the exact same type of appeal rights or judicial review rights for permits to install for existing sources as new sources, they could have done so. But they did not. They expressly carved out permits to install for existing sources from the rights created in 55058. They must have done that for a reason.
Even with this crossover, it does it. You think it's expressly? It says it expressly, even when you look at the crossover.
Even when you look at the crossover, Your Honor, the crossover does not refer specifically to permits to install. And all it tells you to do is go look at 550614. You can look at 550614 and you will not find anywhere in there a reference to permits to install. It does reference up front permits to operate under 55056 under a different type of appellate right. The argument that the environmental groups are presenting is that you should find that same judicial review right for a 90-day period in the sentence after the right creating a right to appeal for operating permits only.
Thank you, counsel.
Good morning, Your Honors. My name is Christopher Bisdock. I represent the South Dearborn Environmental Improvement Association. I would like to address Part 55 first and then MCR 7.119 and the APA second. Justice Markman, I'm happy to have the discussion of, or Chief Justice Markman, I'm happy to have the discussion of standing at any time. On Part 55, the linchpin of our position is you could not write the cross-reference any broader than it's written. You could not write the sentence where the cross-reference lands in 5506.14 any more broadly. It doesn't say, the cross-reference doesn't refer operating permits to 5506.14. It doesn't refer some small set of permits over. It doesn't refer APA appeals of certain permits over. It says appeals of permits for existing sources, which are the majority of sources, as Justice Bernstein pointed out, move over to 5506.14. And 55058, as Justice Zara pointed out, initiates by saying these are the appeal rights relative to a set of categories of permits would include permits to install. When you get over to 5506.14, you could not write the language of the sentence we rely on any broader. A permit. Every other sentence, and we had a long sort of, where we combed through the sentences in 5506.14. Every other sentence that is referring within the text of 5506.14 talks about that permit, such a permit, an operating permit. Every other one of those sentences specifies some specifics, because when you're dealing with existing sources, there are certain situations referenced by Mr. Gordon, my colleague, where you have due process rights relative to existing sources. So there's some extra bells and whistles, there are some extra procedures for existing sources. But the referent over for existing sources, full stop, to 5506.14, and then where it lands in 5506.14, and it says appeals for existing sources, where it says judicial review of a permit is within 90 days, that's where we hang our hat. The cross-reference is the key for us. If you give meaning to it, we prevail. If you nullify it, they prevail. On Part 55. The steel company says in their brief that you should nullify it because really all that's happening, the quote is, the cross-reference quote, calls the reader's attention to the fact that operating permits are addressed in the next section. Statutes don't need to do that. Statutes don't need to tell you in one section what's coming up in the next section. That's a gloss or a spin to try to make their interpretation not meaningless surplus as far as that cross-reference goes. They've also said, we are taking that one sentence from 5506.14, we're taking it out of context, and we're saying, well, a permit means any permit. Well, a permit does mean any permit, first of all, but second and more importantly, that it's because the cross-reference brings it over. and then the review right within 90 days of a permit is unqualified. You couldn't write those two sentences, which are the key for us under Part 55, more broadly than the legislature wrote them. I want to talk about 119, if I may. I want to make 5 brief points about 119 and the APA. The first point comes from the plain text. There was discussion in the briefs, and there was discussion here today, which assumes that this is a rule about contested cases. The rule doesn't say that. The rule says where the APA, we're all abbreviating MCL 224.201 ETSEC as the APA, where the APA applies. MCL 24.313, which we cited in our brief, says the APA applies to all agencies and all agency proceedings, which are not expressly exempted. I think that's as far as you need to go. The APA applies to all agencies, which are APA agencies, not 7.123, MCR 7.123 agencies, which are basically any governmental entity other than a trial court, but all APA agencies and all APA agency proceedings are the APA applies to it. So the link is there. My yellow light went off, my red light didn't come on. I'm not sure where that means I stand.
You have almost 15 minutes left. You got lots of time.
That means
Okay.
we can start
But we
questioning
can
you.
start questioning you now. So
Please,
get ready.
I will. 119.
If we read the APA as broadly as you suggest, is there any purpose to the 21-day provision?
In MCR 7.123?
Yes.
Yes, because there are all sorts of governmental entities that are not APA agencies, that are not state administrative agencies within the executive branch, and they make decisions, and those decisions, as far as a catch-all, are governed by 7.123.
What are some examples of those? I'm just trying to figure out what that means.
The reason I'm struggling with your question is I do air work and I do Michigan Public Service Commission work, so I don't have a lot of expertise in other types of governmental entities, and so I'm relying merely on the rule that says I've got a rule in 7.119, and the rule in 7.119 talks about agencies under the APA. I've got a rule in 7.123 which talks about any governmental entity other than a trial court not covered by another entity under these rules. So I'm just struggling from a background of experience to be able to come up with what other agencies would be involved, because I don't do, other types of cases along those lines. But any other government entity other than a trial court is what 7.123 says that it applies to. The state definition under the APA of an agency applies to DEQ. The state definition under the APA of a license applies to this permit. Nobody disputes this permit as a license. The process that the DEQ went through of reviewing an application, considering information, and issuing of permits is a defined term in the APA licensing. So you have an APA agency who issued an APA license using an APA licensing process. And the claim is that the APA is somehow not applicable to that. Applicable means relevant, or applies to means relevant or applicable. So the argument that an APA agency issuing an APA license after an APA licensing process, that the APA is not relevant to that, is hard to fathom. The rule used to be, our second point comes from the change in the rule. The rule used to be, as Mr. Gordon states, it used to be appeals from contested cases. The old rule was 7.105, was amended I think 7 or 8 years ago. We discussed that in our brief. It used to be appeals from contested cases. Contested cases was removed from the title, and it was removed from the operative text of the rule. And now the rule just says where the APA applies. And the APA says it applies to all agencies and all agencies' proceedings as those are defined under the APA. So it used to be, we would have lost this case 9 years ago. And we wouldn't have proceeded under a rule that says contested cases 9 years ago. But the rule was changed. The rule was broadened in scope. If that change had any meaning at all, it was to eliminate an interpretation that it is solely limited to appeals from contested cases, when those very words were removed from the rule. The committee comment is our third point. And I know that's not binding on the court, but I think the committee comment on the rules interpretation has some weight. It has more weight than the interpretation of the regulatory agency, I think, in this instance. The committee comment says not every agency is subject to the APA, as defined in 7.1021, to refer back to Justice McCormick's question. Not every agency, the committee found, is defined as an agency. Let me rephrase that. Not every agency, as defined in 7.102 of the court rule, is subject to the APA. An agency is subject to the APA if the agency meets the definition of an agency in the APA, Section 203, Sub 2. So we have the committee's interpretation is when the rule was changed, the APA applies to agencies and the activities of agencies under as defined by the APA. The fourth point deals with the details. The steel company says, in order for the APA to apply to a decision, the APA there had to be some specific activity or some specific action that was taken where the APA was expressly invoked. And we don't agree with that for all of the reasons I just mentioned, because of the broad language, et cetera. But even if that's where we have to meet them, we can meet them there. And we talk about this in our brief. We talk about 24.292, which is the section of the APA where you have an existing source as they are, the existing source is in violation as they are, and the state commences some proceeding to suspend, revoke, or amend their license. That process occurred. We documented from the administrative record in this case and excerpted and quoted the back and forth during which that's how this all began, was that the agency was proceeding with the steel company under 24.292. Our brief also explained that MCL 24.291 sub 2 applies. That's the rule that says whatever happens if you have an entity with an existing license and there is a process under which that license is being changed or amended or a new license is being put in place, they keep their old license until that happens. That is, again, a provision of the APA that applied to this licensing process, which was a licensing process under the APA.
When the Circuit Court Appellate Rules Committee removed reference to a contested case in reference to the APA, why is it not that that could have been to facilitate the declaratory action portion? In other words, if it was limited to a contested case, there wouldn't be an appeal from a declaratory action. Opposing counsel suggesting that what's covered by the APA is declaratory action and contested cases.
To the extent that we're parsing the intent of the committee, I take the words.
Well, let's just go with the words of the rules in the statute.
The words of the rules and statute are framed as broadly as they could be framed. If the APA applies to the process, we go under 7.119. If they wanted to limit it to contested cases and declaratory rulings, they could have said that instead, but they didn't.
But there wouldn't have been declaratory rulings covered by the appeal process under the old language, right?
That may be true. I could not tell you. I didn't have a case where that arose at that time. Finally, and I think this gets back to Justice Bernstein's question about what does it matter if we rule the APA applies earlier in Mr. Gordon's presentation. The argument that the steel company makes that you have to find some specific and particular aspect, as we believe we can under 291 and 292 of the APA, but the argument that you have to hitch some aspect of the decision to some particular micro aspect of the process really makes it hard to interpret what court rule applies and what time frame applies. If Part 55 doesn't provide us with 90 days and we are within the 60-day period under the question of the 60-day period under 7.119 or the 21-day period under 7.123, it needs to be clear. A rule that says 7.119 applies to agency decisions where the APA applies, and the APA says the APA applies to the activities of APA agencies is clear, it's understandable. An argument where we have to get into the specifics of an administrative record and what was cited or invoked in a letter between the agency and the steel company at some point in the process to figure out what court rule are we applying and what deadline we are applying is very, very unworkable. So the extent that we are trying to be forward-looking, as Chief Justice Markman, you indicated at the beginning of, at the opening of court this morning, being forward-looking is being clear, being simple. And so the way to interpret 7119 that's simple, that hews to the plain language, is to say it applies to decisions by APA agencies acting under the APA. That's what the APA applies to. That's what the court rule, specifically referencing APA decisions, should apply to.
Okay, thank you, Counsel.
I'm happy to address standing as well.
I don't see any further questions, but if there are, this is the time to do it.
I'll ask you. Address standing, please.
I've been working in this neighborhood since 2003. They live under this plant. This permit increases the emissions of particulate matter, fine particulate matter, of coarse particulate matter, of acid gases, of metals, which are neurotoxins. They have steel kish. This is all in the administrative record that rains on their houses. Their kids go to the Salina Elementary School, where the air pollution monitor for this facility is located. It's so close to the facility, they have the monitor for the pollution from this facility at the elementary school. We are happy to have a standing motion any day of the week and twice on Sunday.
I didn't hear that you were going to have one, though.
Yeah, I thought Mr. Gordon conceded particularized injury.
I believe that the state has been has played that very straight up.
Thank you. I think you exceeded your time by several minutes.
I have a question, so I'm going to let him. He can ask. He can come back, and I'm going to give him a chance because I have a question. So I'd like you to address, if you could, the workability that your brother counsel just talked about. How is the public supposed to deal with this workability issue and determine what type of a source it is? I mean, if I'm living in this environment, if I'm living in this community, how am I supposed to know how to work through these statutes and work through these guidelines? Aren't you putting a tremendous onus on me as a member of the population and a member of the community to do an interpretation? And all we're talking about here is a time sequence. Whether I get 60 days or 90 days or 21 days to be able to have a voice in the process. And you're ultimately trying, in a lot of ways, to kind of cut that out. So explain to me the equitability of that.
Sure. Absolutely, Your Honor. I don't think there is any confusion that the public would face. These permits are clearly labeled. This permit is identified on its face as a permit to install. It is a smaller part of a much larger permit that the facility has called an operating permit or a renewable operating permit. So the public knows ahead of time, as they did here, which kind of permit is at issue here. And I think, Your Honor, to address your earlier question, is there somehow something unfair for only having 21 days to file an appeal for a permit to install, but 90 days for one of these operating permits? We can only go by what the legislature said. That is what the legislature said here. But that's, if I can posit a rationale, it would be that these operating permits, for which you get a longer time to bring your appeal, are permits that govern the entire facility. Permits to install are permits that govern individual operations within this steel mill. There are more than 10 individual operations within this facility that have individual permits to install. They are all consolidated into one overarching renewable operating permit. And there is some logic to having a longer period of time to challenge a overarching operating permit that is much more comprehensive, 90 days, than it is to challenge a permit to install for a discrete operation within that steel mill, which under the rules is 21 days. And then very quickly, 7119 is clear here. Frankly, the question is this an appeal to which the APA applies? And as we discussed earlier, the APA provides for an appeal for only 2 things, declaratory rulings and decisions after contested cases, and I would emphasize that the committee comment to 7.119 backs that up. It says 7.119 is based on the Administrative Procedure Act, particularly the judicial review provisions in 24.301, 302, and 306. Those judicial review provisions say that the APA governs an appeal from an agency decision in a contested case. In other words, the committee comment to 7.119 itself reinforces the conclusion that it applies to appeals from agency decisions in a contested case. 7.123, it may well apply to non-APA agencies. Granted, that's correct. But it also applies to all those other kinds of agency decisions that are not declaratory rulings or were not made in a contested case.
Let me get you back to the NREPA. Questions of statutory interpretation that end up in this court are often difficult to work through. If they're clear, they don't usually get here. That doesn't make them ambiguous. Opposing counsel pointed out that 5505.8, 5506.14, legislature clearly, by reference, suggests that they work together. They were aware of each other. In 5505.8, when it's referring to a permit that is referenced above, it says such a permit shall be filed no later than 90 days after new grounds for renewed arise. But in 5506.14, it's not referring to such a permit. It's making a very broad statement to a permit. Why isn't that a significant textual clue that suggests to us that a permit means just that, a permit?
Because I think you don't, when you're doing statutory interpretation, as the court is well aware, that you don't read the phrase a permit in isolation. I think you need to take it in the context of the two parts of 5506 sub 14. Each of the first part says who gets a permit, who can take an appeal for what kinds of permits, owners and operators.
You're begging the question, though.
Well,
in 5505.8, when they're referring to the above permit, they say such a permit.
They do. They
don't
do.
in 55?
I think when read in context, it is specifying that sentence, the fourth sentence of 5506 sub 14, is specifying the how and when. How do you take an appeal? It's by filing a petition for judicial review. And when? 90 days. The what that it refers to, a permit, was specified in the previous sentence. What is it that the fourth sentence, that phrase, a permit in the fourth sentence refers to? It refers back to the operating permit in the fourth sentence. And that's a parallel structure that is set up in the first two sentences of that. The first two sentences says who, owners and operators, of what, operating permits, general permits to install, and then the next sentence similarly says how and when. Petition, you go contested case followed by judicial
Would you
review.
concede to me, though, that if we were to accept that argument, then the word such in 5505.8 would not really be necessary?
I think you would, if you read it in context, if they omitted the word such in 5505 sub 8, I would have the same, I would read it in context that same way, that is referring back to the permit to install, general permit, and permit to operate referenced in the first sentence, 5505 sub 8.
Thank you, counsel.
Thank you.